I do indeed smell weed. I don't have a seat. I can smell it. This nice officer here can also smell it. Deputy First, can you smell the marijuana coming out of this vehicle? Yes. That is 3, 2, 1. So, do you have a medical marijuana card that is valid in the state of Florida? You just watched a common police tactic unfold in real time. The officer didn't accuse, didn't search, just stated, "I smell marijuana," and waited. That pause is deliberate. It's designed to see what you'll say next. For most people, the very next sentence becomes a mistake. This isn't about whether cannabis is legal. It's about how quickly an encounter can escalate based on your reply. This video breaks down exactly what to do after that moment, using plain language and real scenarios like the one you just witnessed. If you want to lower stress, avoid unnecessary searches, and maintain control of the interaction, here are 5 things you must know. Number 1, do not admit anything. When an officer says, "I smell marijuana," the situation subtly shifts from casual contact to a fact-finding moment. What you say next carries more weight than most realize. Many believe the clever move is to explain, to say it's old, it belongs to someone else, it's legal, or they smoked earlier but not now. Those replies feel harmless, but legally, they are admissions. The law permits officers to use your own words to justify further detention, a search, or even charges. You may think you're being honest or cooperative, but from a legal standpoint, you're filling in blanks the officer doesn't yet have. Silence, however, creates no evidence. You are not required to assist an investigation against yourself, and choosing not to speak is a protected right, not an act of guilt. Understand why this moment exists. Stating, "I smell weed," is often used to gauge a reaction under pressure. Officers are trained to listen for hesitation, nervous explanations, or corrections, details that can later be framed as indicators of guilt. Once you admit to past use, possession, or even proximity, the encounter frequently escalates. What might have ended quickly becomes longer, more intrusive, and harder to control. This isn't because you did something wrong, but because you offered information that altered the legal posture of the stop. The law does not reward honesty in these moments. It rewards discipline. You may remain silent beyond basic identification. You do not have to answer investigative questions. This isn't about being disrespectful. It's about setting boundaries. A simple response such as, "I'm not answering questions," or "choosing silence," is both lawful and effective. You need not justify your silence or explain your reasons. The Constitution protects your right not to incriminate yourself, even indirectly. Exercising that right calmly helps prevent misunderstandings and limits what can be used against you later. Number 2, do not consent to a search. When an officer says they want to search or hints at it after claiming they smell marijuana, you've reached a critical juncture. Many believe consenting will make the situation end faster or appear cooperative. In reality, consent strips away one of your strongest legal protections. The moment you agree, you grant permission to look within the scope of that consent, and you surrender the ability to challenge the search later in court. Even if nothing is found, the search itself can prolong the stop, raise new questions, or uncover issues you never anticipated. Consent does not protect you. It protects the search. Recognize why officers ask instead of simply searching. If they already had clear legal authority, they wouldn't need your permission. When they ask, it's often because consent is easier than justifying probable cause later. Many say yes because the request feels casual or polite, but it is not a small favor. It's a legal shortcut. By agreeing, you make their job easier and your position weaker. The law does not require you to help law enforcement gather evidence against you. Refusing consent is neither illegal nor disrespectful. Your response should be simple and direct. You need not argue or explain. A clear statement like, "I do not consent to any searches," is enough. Say it calmly once, then stop talking. Adding explanations reopens the conversation and creates confusion. You are setting a boundary, not starting a debate. If the officer pressures you, repeat the statement or stay silent. Consistency matters more than tone. Some worry that refusing will automatically lead to a search anyway. Sometimes officers may proceed without consent, but that decision carries legal risk for them. not you. If they search without permission, the legality can be reviewed later by a judge. If you consent, that review usually never happens. This is why attorneys consistently advise against consent, even if you believe you have nothing to hide. If a search happens despite your refusal, do not interfere physically or verbally. Interference can lead to additional charges and unnecessary escalation. You may state, "I do not consent, but I will not interfere," and then remain quiet. This preserves your rights while keeping the encounter from worsening. Your goal isn't to stop the search in the moment, but to protect your legal position afterward. Not consenting is one of the simplest and most effective ways to do that. Number 3, ask the detention question. After an officer mentions smelling marijuana, and you've admitted nothing and refused consent, the next vital step is clarity. Many encounters drag on because people never ask whether they're actually being detained. Officers may continue talking, asking casual questions, or lingering in hopes you'll say something useful. This creates confusion and pressure, and most people respond by filling the silence. The detention question cuts through that uncertainty and forces the interaction into a clear legal lane. The question is simple. Am I being detained, or am I free to leave? This is not a challenge, and it's not disrespectful. It's a lawful request for your status. If the officer says you're free to leave, the interaction is over. Leave calmly and immediately. Do not stay to explain, argue, or make small talk. Remaining after you're told you can go only creates opportunities for the situation to reopen. If the officer says you're being detained, that's important information. It changes how you should behave next. When detained, your obligation to answer questions does not increase. In fact, this is when staying quiet becomes even more crucial. Detention means the officer believes they have legal reason to hold you temporarily, not that you must assist their investigation. Once detained, stop answering investigative questions and avoid volunteering information. Officers may avoid a direct answer, responding with more questions or saying something vague like, "just hang tight." That's often a tactic to keep the encounter open without committing to a detention. If that happens, repeat the question or remain silent. You are not obligated to help them decide. Forcing a clear answer protects you from being held indefinitely without cause. This question matters because time works against you during a stop. The longer an encounter lasts, the more opportunities arise for mistakes, misunderstandings, or escalation. By asking the detention question, you shorten the interaction or at least define it. Courts look at whether a person was free to leave when evaluating the legality of a stop. Your question creates a clear record of that moment. Asking does not guarantee the stop will end, but it prevents it from drifting. It shifts control back to structure and law, instead of uncertainty and pressure. Used calmly and at the right time, it's one of your most effective tools to protect yourself and limit how far the encounter goes. Number 4, do not try to beat the smell argument. When an officer claims they smell marijuana, many immediately try to argue their way out. They say weed is legal, that smell alone isn't proof that it came from someone else, or that it must be from outside. While these points may sound logical, the roadside is not the place to win a legal debate. Trying to beat the smell argument almost always backfires. It keeps you talking and gives the officer more information to work with. The more you explain, the more details you provide, and those details can later be used against you, even with good intentions. Understand how the law treats these situations. Courts, not officers on the street, decide whether a claimed smell justifies a search or detention. Officers are allowed to state observations, and they aren't required to prove those observations to you in the moment. Arguing doesn't make the claim disappear, it only extends the encounter. Even correct legal points can hurt you if delivered at the wrong time. On the street, talking rarely improves your position. Many also believe that confidently correcting the officer shows they know their rights. In reality, it often signals nervousness or defensiveness, which invites more questions. Officers are trained to let people talk themselves into contradictions. One explanation leads to another, and soon the conversation drifts into unrelated areas. This is how small encounters turn into long ones. The smarter approach is restraint. You don't need to agree with the officer, and you don't need to challenge them. You can simply decline to engage on the topic. Silence or a neutral statement like, "I'm not answering questions," prevents the argument from even starting. This keeps the focus on what the officer can legally do, not on what you can be pressured into saying. If the officer is wrong, that's addressed later through legal channels, not in the moment. Video and testimony are reviewed after the fact. Your goal isn't to prove the officer wrong on the spot. It's to avoid creating new issues while the situation unfolds. Try and win a roadside debate feels empowering, but it's usually a trap. Discipline and patience protect you far more than clever arguments. By refusing to engage with the smell claim, you reduce risk, shorten the interaction, and preserve your ability to challenge what happened later. Number 5. If they search anyway, do not interfere. Even after doing everything right, no admission, no consent, disciplined words, an officer may still decide to search. This is frustrating, and for many, it feels unfair. But this is the moment where restraint matters most. Interfering with a search, even one you believe is unlawful, almost always worsens the situation. Physical resistance or verbal obstruction can lead to additional charges unrelated to the original stop. Then, the focus shifts away from the legality of the search and onto your behavior, weakening your position. Recognize how the law views this moment. Officers make decisions in real time, but courts review those decisions later. The legality of a search isn't decided on the street. It's decided in a courtroom based on reports, body camera footage, and testimony. If you interfere, argue aggressively, or physically block the search, you create new legal problems that can overshadow the original issue. Even a search that might have been ruled unlawful can become irrelevant if new charges are added. The correct response is calm and clear. You may state, "I do not consent to any searches, but I will not interfere," and then stop talking. This preserves your objection without escalating the encounter. Saying it once is enough. Repeating or arguing beyond that point increases tension. Your goal is to document your lack of consent, not to stop the officer in that moment. Some feel that staying quiet during a search looks weak. In reality, it shows discipline and awareness. Silence prevents accidental statements, emotional reactions, or misunderstandings from entering the record. Officers are trained to note behavior during searches, and anything you say can be interpreted in unintended ways. Remaining calm protects you. If something is found, or if nothing is, the next steps happen later. That's when attorneys, judges, and evidence rules matter. Your behavior during the search will be part of that evaluation. Calm, non-interfering conduct strengthens your credibility and preserves your ability to challenge the search legally.